Hello everyone, and sorry for being late today. We are late of 8 minutes. The ironing of my coat and my facial mask with humidifying cream has taken longer. My assistant was extremely slow, and it's really not my fault. It was my assistant who was delayed in massaging my cheeks so that they are most beautiful for you guys. But I'm here now. I took it under my own hands. How are you doing, Frame Game?
I'm doing great. I think, yeah, we also have a beautician for this presentation today. It's going to be a great one.
Can't wait. So we started last week and we talked about the political networks around the Starbucks affair. This whole affair where there was a there was two guys. They were sitting there not buying coffees, and the manager called the police and said, "These guys don't want to leave my establishment and they don't want to buy anything. Can you do something about it?" Um, and it turns out that this has led to a campaign across the nation, which resulted in Starbucks having to offer a training, a racial awareness training to all of its employees. Now you're telling me there are some news developing on the Starbucks sides this week?
That is correct. So, in addition to the Starbucks training, one of the key takeaways from the saga of last week was that an underreported fact, one not reported by mainstream media, was that in addition to the training for 175,000 employees in 8,000 stores, there was also a free college paid for both of the gentlemen, plus a undisclosed confidential financial settlement, the amount of which we will never know. While everyone was told this case settled for $1 and some money to charity, these guys got rich, and we are following the saga again this week.
Absolutely. And so what's been happening? Did we get a revelation about these deals or not?
We did. So I just sent you a link in the lobby. This is something that went around the Twitter sphere as well. And it is that Starbucks announced last week, I think on like Wednesday of last week, all met with the community organizers at Power, with members of City Council, with the two individuals. And this is, they have very important things to do as heads of this juggernaut business. So why do they
So
care so
people
much
are
about
telling
City
me that
Council?
Frame Game is muted. I don't think that's true, guys. I see his audio here, but for some reason, people on the chat are complaining that you are muted. Let me just make sure that everything is all right. However, on my side, okay, they said the sound is back. Okay, so we lost Frame Game for a few seconds, but now you're back. Can you make a test, Frame Game?
Yes, testing, testing.
Okay, everyone in the chat, type 1 if you hear him, and type 2 if you don't hear him. Okay, they say you're back. Perfect.
All
So we had
right.
lost you for a moment.
All right, so I'll make it a quick recap. One of the things that we covered last week is the answer to the riddle of why the head of this multi-billion-dollar enterprise, why the CEO, the chairman, the founder are all having these one-on-one meetings with the dinky little community organizers in Philadelphia and with Philadelphia city councilmen and with the two individuals who were loitering at Starbucks. And if you recall, one of the things we covered was the super importance of political sway that Starbucks must maintain over local city councils. And we covered their dispute with Seattle, where they had to basically pay Seattle to not pass this Starbucks tax that would have cost basically $50 million a year and potentially spread throughout city centers across America. So,
Now,
what were, wait, sorry, go on.
now this whole it's like the decolonization. It's like when France had an empire and then they withdrew, and And they said, okay, we're not gonna be involved in these islands anymore. We don't make enough money there. Do you think that the motivation here is to avoid trouble? Is it money? Is it racial diversity motivations underlying this clause?
Well, it's a number of reasons, but chief among which they cited in the article that I sent you and a number of others, is that increasing levels of regulation set upon them by local city councils in big cities have really eaten into their bottom line. That is, mandatory minimum wage laws, often set at around $15, and other kinds of regulatory demands, which we'll cover this week, include things like mandatory investment into, say, black majority areas, if you're going to expand there, so diversity supplier programs, and a number of other basically pay to play situations that have evolved over the past several decades as a anteing up to get your seat at the table to do business in the big city.
All right. So it seems so you're telling me that there are $15 minimal salaries. Is this at city levels?
At some. So this was it's been a big push to get $15 minimum wage. I think that started a couple years ago. And I believe that New York State has some aspect of it that was recently sort of embraced. I don't know the exact list of cities at this point, but that was, if you recall, what the power community activists were pressing for. And it's been a big political push for progressives that has been a thorn in the side of liberals.
All right. So let's get through it. What do we start with?
So let's start with the presentation. And this week we are going to answer the question of how did we get here? Play ball. And there was the question about whether or not they were cucking, that is, sort of surrendering to the diversity industry, or whether they were doing it as a power play to control various aspects of it. So why is Starbucks doing this, and how did we get here? Is the subject we're first going to turn to. And we're going to do a legal primer first, so that at the end of this presentation, everyone will be a mini expert in civil rights law, at least
right.
as it pertains to this space. So the story begins really in 1875, and this is now in the I don't know if you want to pull it up or if you want me to.
Yeah, I can put it up, but I just need a moment to copy your audio because people are telling me that's why we were losing your audio. Every time I show that presentation, the audio disappears. I will just fix that little thing here. Let me just try something. What if I paste the audio? Now, if you speak.
Hello, hello.
Perfect. All right. So I am at how did we get here?
All right. So start with our history.
All right. Our history. Pre-1964.
Right. So if you click on the present button, you should be able to see the whole thing. So we're going to treat the year 1964 as if it is 0 AD, the start of the common era of the diversity industry. But first, here's a brief primer on what happened before the crowning achievement of the American civil rights movement. 10 years after the Civil War ended, President Ulysses Grant, he the general of the North, signed into law the Civil Rights Act of 1875, which guaranteed equal access to public accommodations, whether you were black or white. And the idea was, as we discussed last time, that if you are a business, a public accommodation such as an inn or a train or to some extent a restaurant, then you could not deny service to somebody on the basis of race. This is something a lot of people are surprised about, that it dates back as early as 1875. But the idea was, in a humanitarian way, to try to preserve the American principle of freedom of association and freedom to do business however you please, while also preserving life. That is, if you're traveling on the road and you need a place to stay in the cold, you will be treated, you'll be given full dignity as a human being.
All right.
So beginning in 1883, this was overturned with a series of Supreme Court rulings that we don't need to get into. And then there was the famous case in 1896 of Plessy versus Ferguson. Plessy versus Ferguson basically solidified that the 1875 Civil Rights Act was invalid and unconstitutional, and it held that separate but equal is legal. And that formed the basis of what SJWs now sort of refer to as the full suite of Jim Crow laws that existed between sort of 1896 and 1964 that the 1964 Civil Rights Act was designed to destroy. So now let's turn to what happened in 1964. Why is this year zero? So if you go to the next slide.
All right. What you heard?
You heard that the 1964 Civil Rights Act was the crowning achievement of the civil rights movement, and it did three things. It prohibited discrimination in public places, like the 1875 Act did. It provided for the integration of schools and other public facilities, so full desegregation. And third, it made employment discrimination illegal. And this is where we're going to focus, because this third prong contained in Title VII of this act is the lever that has been leveraged to create the modern diversity industry, far beyond employment.
It was
So
to
here's what
lose. It allowed a kind of hook for the diversity industry to use as a threat that any potential action may fall under that point 3, as you've described before.
Right. And it was done with the Martin Luther King, sort of maxim in mind that, that I signed up for, that many people before understanding the extent of the diversity industry signed up for, the idea that people should not be discriminated against at an individual level. Now, your mileage may vary on that, but what has happened in the intervening 50 years is that Martin Luther King is no longer the law. What you didn't hear is that the 1964 Civil Rights Act ended freedom of association as we know it. It ended the libertarian principle of businesses being able to do whatever they want. And third, it left punitive damages and uncapped liability that affords an infinite opportunity for lawfare. So there's a clip here that so there's a clip here, if you click, that does a good job of introducing some basic tenets here, if you want to give it a whirl.
All right. I don't know how many times I have to click it. It may not be playing. If you can send me the link, it will be better, I think.
Sure. Yep. I'll move on to the next slide in the meantime, and then I'll send you these links.
All right.
So what you were sold with Title VII of the 1964 Civil Rights Act was an end to what's called disparate treatment of individuals on the basis of race. Disparate treatment is distinguished from what has come to be called disparate impact. Disparate treatment means treating people differently. Disparate impact means it has a different net effect on different groups. So what was initially designed to prevent treating people differently has now become required law that you treat people differently. It has been completely inverted, owing initially to a case we're going to cover briefly in 1971 called Griggs versus Power. So let me send you this this link here that in the lobby. Hold on a second.
So it seems that the inversion you describe is kind of an inversion between equality of opportunity and fairness of treatment versus fairness of outcome.
Right, and getting rid of the idea of treating people but on the basis of who they are, and instead having to make threshold determinations about what race somebody is, and then having to play the racial balancing game. So hold on one sec while I try to pull this up. I have it all uploaded onto a separate account.
All
Here you
right,
go.
no problem. Now, while you do that, I will comment on a news story that I've not commented on. It's this woman who's now called Permit Patty, who has reported to the police because there was a girl on her street who was selling water bottles, and this girl called the police because, well, she was annoyed by the noise and by the screaming at first, so she asked her to leave or stop screaming. And the mother of the young 8-year-old girl was was kind of taunting her and saying, "All right, call the police and ask them if you need a permit for an 8-year-old who sell bottles of waters." And she did call the police. Apparently, not to get the police to arrest them, but call the police genuinely to respond to the mother's request, saying, "Hey, is it true that you can sell bottles of water on the street like this? You probably can't, as far as I know. I know that there are city regulations on all sorts of street selling, and I'm pretty sure you do need a permit. However, it is generally tolerated when kids do it, I guess." And so this whole thing has blown up out of proportion, and now she's getting harassed because the kid was black, and there's lots of people thinking that her calling the police was an act of racism. uh I mean, I don't even know what to think about this frame game. What I'll say is, personally, as a libertarian, I'm very annoyed by the people who are annoyed by their neighbors. Like, I had a neighbor at some point. I was living in a small apartment, and he was complaining that we were making too much noise at 10 p.m. In the night, and I was like, we are making much less noise than you and your children who are screaming. And it had turned out that this guy was a Muslim, and so I was being accused by the owner of the land to be anti-Muslim. I was like,
Oh,
I'm not
no.
anti anything. I'm just asking for peace in my apartment. It's not the noise that they were complaining about. I don't make parties. I don't have friends. The noise was like me walking to the freaking bathroom. And his children were screaming down there, and I was so libertarian about it. I was like, let the children scream, I don't mind. But he minded when I was getting out of my bed to go to the freaking bathroom. I'm annoyed by these permit patties, and so I'm not very sympathetic to this old lady who called the police. I think these people are annoying. When you live in town, you gotta deal with people around you, and yes, the space is constricted, and so everyone lives closer to each other. If you don't like it, go buy a land for $1,000 in the forest like I did, and there's no one who's ever gonna bother you. Now, that's my take. However, of course, she's getting a backlash that is not warranted in my view either. So I'm both unsympathetic to her, and also I'm unsympathetic to the campaign of harassment and the calling her a racist. That's
Of
nonsense.
course. Of course. Well, there's no truer test of libertarianism than this topic we're talking about tonight. So we're actually going in reverse order. Just to give the chat a little bit of entertainment first, play the last clip that I sent you in the lobby first. It's 1:45, explaining the end game of where we are now by someone who used to work in the Office of Civil Rights.
All right, let's have a look. So, disparate impact in education. Oh, an error has occurred. Please try again later. Let me try to refresh that video. Okay. Oh, no, it shows up, but then it disappears. It seems that the
I
videos
have
are unplayable.
I do have a lot. I do have a local version that I can try to upload into the thing. If it doesn't work, then we'll do it without the
I think
presentations.
we'll have to do without because the time for
Okay,
uploading will be too long. So what were they
that's fine.
saying in these videos?
So this was a person at the Office of Civil Rights talking about how he got a panic call from a local school district superintendent saying that too many black children had been classified as or that a disproportionate number of black children had been classified as mentally retarded. That's the phrase that he uses there, and that's I believe that's the PC way of phrasing it. But basically, mentally, special needs or whatnot, and that it was disproportionate relative to their demographic representation in the school district. And so he had called his attorney here to figure out how many white people they needed to classify as mentally slow or special needs in order to comply with federal law.
Oh my god. This is
Um,
scandalous. Are you telling me there's gonna be kids who get found out to be mentally have a mental disorder just to equalize the freaking outcomes? Don't tell me that frame game.
yes, yes. Well, you're going to learn the whole history of how we got there and what that means for why Starbucks has to do what it's doing with respect, tonight. So that is the upshot of disparate impact. If there is a if there is a disproportionate racial classification on something that could be perceived to have to inhibit people's access or success rates to various institutions, you are liable, or at least you are. There's a colorable claim that you are on the hook for millions, if not billions, of dollars. This is a shame about the video clips. I am going to keep just trying to upload locally here while I go through with this presentation because these are all deep practitioners who are saying the same thing that I say. People who've been practicing at the top levels of the Civil Rights Department, Office of the Justice Department for 35 years. Many of them are black, many of them are minorities. There is, this is something that really, it's more about right or wrong than it is about ethnocentricity. Um, but while I'm doing that, maybe I'll pull them up at our first super chat break. So
All right.
let's continue with the slideshow. And I want to kind of just state what the new legal standard is after the case we're about to cover in 1971. And that is everything is illegal. Absolutely everything is illegal, or at least there's a colorable claim that it is. And it relates to the next slide here, this case called Griggs versus Duke Power. So here's what happened, JF. Up until 1971, Title VII of the Civil Rights Act had only meant that disparate treatment was illegal. That is, you can't treat a black person differently because he's black. You can't treat a white person differently because he's white. What happened in Griggs versus Duke Power was the plaintiff, Willie Griggs, filed a class action lawsuit saying that his employer required a high school diploma and passing a few aptitude tests in order to qualify for higher management positions within the company.
Okay.
And Griggs alleged that this was done specifically to keep out black employees, to keep them from rising up the food chain at the company because disproportionately fewer black employees had passed had high school diplomas.
Mm-hmm.
So, what do you think of that, just off the top of your head? Do you think that that should be illegal to require a high school diploma to qualify for upper management?
Well, I don't think it should be illegal, and in fact, I would be very worried if it was illegal because that would mean literally, and because I thought that the education achievements were the last were the last kind of IQ test allowed to companies, and so if you cannot discriminate by educational achievement, then you literally cannot discriminate by anything because they've already made it illegal to test via IQ. And so educational attainment used to be the last stand. Are you telling me that we can't?
Right. I'm telling you that you can't unless you qualify for certain exemptions. The the policy, if it results in a disparate impact, which is literally every single law or policy in the world, um, you need to prove basically three things, two of three things. You need to prove that the policy is related to the job itself and that there is a business necessity for it, and that there is no more narrow way of achieving a similar result absent this particular policy.
Wow.
If you
So the
cannot
burden
prove those
of
three
on
things,
proof is on you.
that is correct.
Wow.
So, so in this case, the argument was that a high school diploma was not necessary for certain high level positions, and accordingly, the employer was liable under Title VII of the Civil Rights Act on the grounds that if something has a different impact, then the burden now passes to the employer to prove a business necessity and narrow tailoring. That is, that there's no other way to do it. But this immediately gets you into lawfare zone because there is basically no way to dismiss these cases on summary judgment, meaning there's no way to prove beyond a shadow of a doubt these things. So they have to be litigated in court, which gives the plaintiffs tremendous leverage to sue you for years and years on end without you ever being able to dismiss the case. So let's skip ahead to slide 7 here, because there's a reason that I'm telling that this employment law concept that that this only applies to employees has, in the intervening 55 years, been extended to nearly every area of governance. So this is it's a slide 7 here, and
Is it back?
it
Because right
applies.
now I'm
No,
at
it's
slide
forward. It's forward.
26 forward.
Yeah,
Okay.
it's forward. Yeah. So
So
there are 5 chief areas. There you go.
all
There are
right.
5 chief areas where disparate impact law applies. So one is in corporate policies, terms of service, and business contracts. And I just have in brackets for your reference the relevant governing authorities. Employment, hiring, promotion, and workplace environment dynamics. Education, both public and private, college and university. Housing and urban development, and finance, credit, and lending. So in all of these places, if there is any sort of rule, regulation, or disparate achievement by different groups at your institution, whether that's a private company or a government agency, you are automatically eligible for multi-million and often billion-dollar lawsuits. So you are constantly on the knife's edge because of this. And since I know you doubt me, if you have a beating heart, you must doubt me with what I'm saying. So that's why the next part of the presentation is so critical. But I'll pause now.
But it makes me think about my time back in at Duke University. I was seeing all of these people paid just to think about how can we respect these things more. And I swear I was like, well, who decided to get these people paid? Well, there are people sitting in offices and spending their days thinking, oh, well, I am a public or private university, therefore I have to think about disparate impact and I have to act within the university, and these people end up having a lot of power within universities because the the president or whoever is directing the university, they absolutely don't want any trouble, and so they leave them full authority even over professors. So you end up having people who are secretaries and who are human resource management people actually telling professors who have PhDs how to do their job and how they need to be less racist and think about the disparate impact of their actions in research and in education.
Right. Well, actually, they telling them that they need to be more racist. This is one of the clips that I was going to show, and maybe I'll see if I can rescue it during the super chat break. But it's an attorney explaining how this has never been applied successfully. Don't worry about it. I'll pull it up later.
All right.
How white men do not have the right to disparate impact law. That is, there has never been a successful disparate impact case tried by white men, and the idea is that it is there are many reasons that have been hypothesized for permitting this law on the books, which so clearly on its face violates the Equal Protection Clause.
Yeah.
And part of the reason has to do with basically historical discrimination and the sort of playing catch up for hundreds of years of discrimination. This is something that courts have recognized. The other has to do with the general benefits of diversity. So all of these things are in enormous tension with the Equal Protection Clause. And as we'll see, because of the legal requirements on so many of these actors, they are required to discriminate against white men, or else they are going to lose contracts, or they will not be able to satisfy best practices for defending themselves against these lawsuits. So let's start with the EEOC's 4/5 rule. This is on the next slide here, and you can see it here on the EEOC website. For those who don't know, the EEOC is the Equal Employment Opportunity Commission. But this rule has also been adopted by each of the organizations that I cited above. That is the the OECA, the OFCCP, the HUD, the CFPB, all of the organizations that I mentioned. It's not just employment. This 4/5 rule applies everywhere that there is eligibility for disparate impact lawsuits. And here is what the 4/5 rule says. And if you want to see a bigger image, you can pull up the link. But the 4/5 rule is a way of proving what's called a prima facie case, meaning a case that per se qualifies you to survive summary judgment. It per se gives you grounds for the lawsuit.
So typically what that means for someone starting a lawsuit is that they will not get dismissed within the first 30 or 60 days. They will probably get to a trial, potentially with jury, potentially with lots of cost in lawyers' preparation. And we're talking about a process up to a year minimum, and we're not even talking about the appeals process here.
Right. That's correct. And what's worse than that is that the PR aspect to these lawsuits is true theater beyond the law. But what the 4/5 rule says, and I'm not joking when I say these are the operative guidelines in America, that the rule of thumb is that if there's a selection rate for any race, sex, or ethnic group, which is less than 4/5, that is less than 80% of the selection rate for the group with the highest selection rate, then that per se qualifies as adverse impact and requires the employer to provide justification for the basically business necessity, relatedness, and inability to solve the diversity, the numbers not adding up by other means.
So I have a problem with selection rate, understanding what it is. Are we talking about overrepresentation of 80%, or are we talking about the final pool of people that you would select from any process in education or employment being more than 80% black or more than 80% white? What is selection rate in that context?
Selection means people who, for example, in this case, were hired out of who applied. So you'll see here on the EEOC website, they have a mathematical example. Let's just say you have a job opening and 80 white individuals apply and 40 black individuals apply. And there are 60 slots, 48 white men or white people get the job, 12 black people get the job. So what you have there is a selection rate of 60%. And basically that's if you have less than 4/5, then you're basically potentially liable for adverse impacts. So it's basically saying that you need to, if you have a group that, and there are certain parameters around it, like the group has to have more than 2% demographic representation in the geographic area, and there's some other holistic measures that qualify this. But essentially, if the proportion of black hires is less than 80% of the proportion of white hires, then there is what's called adverse impact for the admissions criteria that you have at your company, and you are liable for a lawsuit that may require either an injunction or damages to force you to change your selection criteria. And we'll go through some examples of that.
So just to illustrate to the audience what's in text here, suppose you have 120 applicants and there's 80 who are white, 40 who are black. You go by their CV, you go by their previous experience, and it just turns out that you end up hiring 48 white people and 12 black people. Now, this is a realistic situation, and it doesn't look like you violated anything. But according to this document, you would end up with a 50% what they call selection rate that is biased against black and for white, and you may be subject to the forfeit rule. You violated it. You've hired too many whites by taking 48 and 12 blacks.
Correct. You are now eligible for a lawsuit without any other showing. So, and this, of course, is it's very expensive to defend lawsuits. You can bring lawsuits essentially for free, but this means the cost of doing business is that you are going to need diversity lawyers on retainer if you are any corporation of any size, beyond a couple hundred employees. So
yeah, actually, any corporation cannot even, if you're a self-employed businessman with like 3 or 4 employees or 10 employees, you'll need a lawyer because you can't even defend yourself pro se if you're a corporation.
Right. So now I want to undertake the task of proving to you guys how serious it is by going through sort of a top 10 of lawsuits and settlements in recent history. And I want to start it off. This is here now, I guess, on slide 9. Maybe play a game with the chat. You tell me a company, we'll Google it, and we'll see how much they've paid in Racial or Civil Rights Act lawsuits.
All right, I'll be handling this game. So chat, name a big company or a company that you think people will think about, and we will ask a frame game to find how much they paid in racial diversity related lawsuit. Go ahead, I will be waiting for 30 seconds. Get your votes in.
While you're waiting, I'm going to go through a few quick examples. So here on the next slide, we'll start out with Coca-Cola. In 2000, Coca-Cola settled before trial, that is a settlement, for $192.5 million.
My God.
For so here you go, click that link, and I want you to see and not just that, a complete gutting of the company's policies. So that's $200 million without even losing the court case.
It seems I can't click. This presentation is very bizarre.
That's unfortunate.
But if you can copy it in the lobby, yep. I will be able.
Sure thing. Here you go. It is in the lobby.
Right. Coke announces $192.5 million settlement. They decided to go for settlement.
Yep. They also agreed to have their employment practices reviewed by an outside group, that is a diversity industry consulting group, an industry we'll get to later in the talk. They will need to pay that group handsomely, I can guarantee you. So basically they have to write off $200 million for the quarter. If you scroll down, you can see a few other aspects about it. So you'll see the watchdog group at the center of the suit. Scroll up a little bit. So there's now going to be a watchdog group at Coca-Cola, making sure that pay is fair and promotions and performance evaluations are fair. 3 members will be appointed by the plaintiff's lawyers. So there's the people who just won 200 million now get a 3-person committee at Coke permanently, along with Coke's chairman. So this is a high-level task force that will be recommending changes and whatnot. And here is everything that Coca-Cola is forced to do going forward, in addition to paying the $200 million. So, goals, milestones, employing a ton of people to take care of the monitoring and to have 24/7 hotline established and all of this. And you'll note that this is modeled after a similar settlement with Texaco. Again, chat, I defy you to find me a large company that has not paid at least tens of millions in this. But let's just do 1 or 2 more before we go to the chat. Is that all right, JF?
All right. A lot of people have pulled EA as opposed to there's people saying Google. There's people saying, of course, the big names. But EA, I'm surprised, has grabbed many votes. However, we can continue with the presentation before most votes come in.
Sure, I'll do 1 or 2 more, and then I'll rise to the challenge here. So here in 2013, just a couple years ago, Bank of America / Merrill Lynch, $160 million settlement. Again, settlement before trial.
It's amazing. I've never seen as much settlements. I've always seen very aggressive big corporations being always willing to do the case in court and to reduce the amount and to make sure that they win if they can. I've never seen a field of loss with so much settlement.
Right. Well, it just goes to show, remember we covered prospect theory and being risk-seeking in the domain of losses. Typically, if you're going to give up $200 million, you at least want to fight, have your day in court over it. But as we'll cover in the next slide, you'll see that the payouts are far more than several hundred millions. They're often in the billions. So I just sent you a link if you would like to check out that Merrill Lynch lawsuit, as well as the 2010 Dodd-Frank legislation, a major financial overhaul that happened in 2010 in the wake of the financial crisis, and it mandated racial and diversity to qualify for government grants in the private sector. So here in the next slide, here is the U.S. Department of Agriculture, which lost at trial, paid $1.25 billion.
Jesus Christ.
That's why you settle for 100 or 200 million. So, and this is a government agency. This is, if you're a private business, public business, if you are a government agency, local, state, federal, it doesn't matter. You are basically, there is a gun to your neck 24 hours a day over this, because there is no cap to the lawsuits. So I don't know if you want me to keep going or try to take on the chat. You guys wanted to Google
let's
or
keep
EA?
going. If you add the examples, let's go through them, and then EA, I think, has won the chat's art.
All right. So here also on that same page, you'll see even the Secret Service, for example, lost at trial and had to pay $24 million because of alleged disparate impact about the rates of hiring and promotion of Black civil service agents as opposed to white Secret Service agents.
This makes me think, did they do a movie of James Bond with a Black James Bond? Because I heard Puff Daddy wanted to be the next James Bond. I think it was 10 years ago, and I've never checked back.
Well, you know what? We're going to get into cases that are actually quite similar to that when we get into the requirement for diversity in advertising, which is going to explain to much of our audience why you see the particular types of ads that you do.
All right.
All right. So here is a famous case from Abercrombie in 2004. They paid basically $50 million plus a complete overhaul of their company policies. There are links for you here. Here, I'll send it to you in the lobby. It is
50
sent.
million.
Right, it was 40 million plus 7 million in attorney's fees. And now look what else. It's not just the money, JF. So, and again, this is 50 million just in a settlement. Again, didn't even lose in trial. The company agreed to a settlement of the class action suit, which required the company to pay basically 50 million to the Diversity Coalition, who were not hired or worked in certain stores. It had to revise its hiring, performance measurement, and promotion policies, revise its internal complaint procedures, appoint a vice president of diversity, hire 25 recruiters to seek out minority applicants, discontinue its practice of recruiting primarily at white fraternities and sororities, include more minorities in its marketing materials, report to a neutral court-appointed monitor twice per year regarding
Holy
its
shit.
progress in these areas,
A
and report
fucking
to this
court
court at least
guardian.
once. Mm-hmm.
I can't believe it. This is like family courts. They take over your life and your freedom.
Right. So it's not just that you have to pay everything. You are a slave to this. You have to monitor it. You have to employ. You need to open up a whole new wing of your office. You need to employ a vice president of diversity and all the staff. You need to employ 25 new people just to seek out minority applicants. And then, you're basically under house arrest, racial house arrest, as a corporation for the rest of your corporate existence.
Wow.
So in the next slide, I just, without getting into too much detail about this, here are just some quick examples of everybody gets sued. Absolutely everybody. Here's the New York Times, Washington Post, CNN, Fox News. And I just have the picture of the bunny rabbit from Monty Python. There's so many people who see the diversity industry as like this David, not the Goliath that it truly is. They think it's just a little bunny. It's a killer. It is an absolute killer.
Wow.
So in the next slide here, you'll see even Denny's in 1994 had to pay $55 million in a settlement before trial because some Black patrons believed that they were asked to prepay for meals where white patrons were not. That was the allegation, and didn't even get their day in court. $55 million right there. Cracker Barrel had the same thing happen to them. You're starting to understand a little bit why Starbucks, for what they did is, calling the police in this instance, it would be so easy for Stuart Cohen, who represented the two plaintiffs, to just say, well, you didn't call the cops on white people in this particular instance. And we have someone who's willing to testify in court to that effect. That right there is
so all of
it's
this,
a way starter.
All of this legal history is kind of a tool of extortion for the diversity industry. It's like you do what we want you to do, or they would have the possibility to have such settlements and such lawsuits.
Yes, well, it started out that way, but it's evolved in an amazing way we're going to cover now that is going to explain Starbucks's why Starbucks is simultaneously this neo-imperial gentrification power with like white and Jewish people in charge. And I say that just as a factual statement, and yet seems to be cucking without having to necessarily pay the price of cucking. And it's because the industry has evolved, and we'll start this aspect of it on the next slide. It's evolved to be not just liability insurance, but a weapon by itself that is purchasing the influence of key actors in the diversity industry, gets you a number of extraordinary competitive advantages over your rivals, which has led to a kind of musical chairs for top CEOs and top companies to try to buy up influence and do weaponized philanthropy, so that they have their proxy warriors and aren't left as being without influence when the music stops. So here is an example. By the way, stop me anytime.
I'm reading your stuff. Are you about to tell me that Black people got TV channels as a ransom for a settlement?
Yep.
You can
So
now
here
claim your
is
own TV channel, people. Okay, go ahead.
well, they
Sorry.
won. Okay, so in 2014, a gentleman named Byron Allen, who purports to represent a black-owned media conglomerate, which is basically just a couple of sort of third-rate, low circulation media channels that are 100% black-owned, and he colors his complaint with that phrase liberally. He sued AT&T for, and I'm not joking when I say this, $10 billion. The lawsuit survived summary judgment, and it was done at a time when AT&T was trying to buy a number of, I believe it was Dish TV or NBC. They were basically, this was one of the mega conglomerate moments that we covered in our media conglomerate episode. Remember, we covered AT&T, Time Warner, Comcast, all
Yep.
of these entities that sit on top of CNN and NBC.
Yep.
So at the time, AT&T was seeking Justice Department approval for its acquisition of, I believe it was NBC, but it may have been DirecTV. And here, I'll send you this link. This link here in the chat. It's well worth pulling up that I just sent you. And he alleged that basically there's something like $26 billion in business that AT&T does, and it only gives about $3 million in business in basically subcontracting to 100% black-owned businesses. So they say 3 million out of 26 billion. Let's do punitive damages and make up for it in sort of restitution. And the damages come out to $10 billion. And this is right around the time where AT&T was under critical review at the Department of Justice for having, they need, when you do a merger of that size, you need approval from the Department of Justice under antitrust laws. And because of the massive growth of the civil rights wing of the Department of Justice over the past 50 years, that is, it is all city politics. Everyone, the seats at the table have grown enormously. Often part of the review of something for a merger has to deal with whether or not it creates equitable results on racial grounds, and whether or not there's an affirmative action program in place that is satisfactory. This is a topic we'll get to later. And so this was a huge bomb that this is during the Obama administration with Eric Holder, who we talked about last week, who was running the Department of Justice. He who has extremely aggressive about shaking down white enterprises for the diversity industry. But I want to call your attention now to the following link. And this is exclusive content here, chat. You only get this here on the public space.
All right, we'll get to the link, but I received a super chat that's relevant. So-called Justice Warrior says, "Oh my fucking god, JF, play a clip of Byron Allen's stand-up. He is painfully unfunny. He had a show called Comics Unleashed. His opening monologues were pathetic." So it seems that we are reducing the quality of comedy if we are giving this guy free stuff.
Well, right. Well, AT&T settled the lawsuit out of court very discreetly and gave them 7 free channels on DirecTV, plus a confidential financial settlement. Now, one of the things that we're going to be talking about here, I'm going to direct your attention to the bottom of page 4 of this complaint. It's number 8.
All right.
And
to obtain support for the, go ahead.
I'm sorry, up a little bit. It's number 8. Sorry, you got it. You're perfect. So it's not just that this was a run-of-the-mill billion-dollar shakedown of a corporation. What happened here was Byron Allen was correct in pointing out he is a guy who is steeped in the diversity industry, and he knows how these things go. And what he called out is that Comcast has been paying Al Sharpton and Al Sharpton's National Action Network The National Action Network is a community organization, a federal community organization with local chapters everywhere in the country, essentially. And Comcast has been paying off Al Sharpton over $4 million, as cited here, in return for Al Sharpton and the National Action Network signing a MOU, a Memorandum of Understanding, to the Department of Justice that the affirmative action program in place for post merger was equitable and approved of, and that this merger was the best thing for racial diversity in America. So basically, buying up votes for approval for people in the Civil Rights Office, and using Al Sharpton and the civil rights groups to do it.
So they give 4 million or 3.8 million to Al Sharpton, and then in exchange, Al Sharpton will stand in front of the Civil Rights Committee or whatever Department of Justice organization and say, "This is good. We approve as big fans of diversity."
Signed a written letter along with several other diversity industry groups. I think this is now going on to point 9. So I'm gonna read this out loud because it's very important for people to keep in mind that this is how the game works. This is Byron Allen's allegation. Sharpton and his organization, like all the other groups that entered into the sham MOUs, that is the written affidavit essentially on behalf of Comcast, are not television channel owners and do not operate in the television channel business. They don't produce content. Ironically, as widely reported in major news outlets, Comcast spent millions of dollars to pay non-media civil rights groups to support its acquisition of NBC Universal, that is NBC, while at the same time refusing to do business with 100% African-American owned media companies. And with these, now point 10, with these MOUs in hand, Comcast proceeded to segregate white-owned media business. And basically it goes on to illustrate what I call the sliding scale, which is the more white and Jewish your your company is, or its executive ranks are, the more you need to pay the diversity industry to protect you from people like Byron Allen and to call off the civil rights plaintiff bar. And I have a thread on this on Twitter we can walk through later if we have time.
Absolutely. Now, just to understand what's going on here, this is a form of purity spiraling into the diversity industry. These guys are saying Al Sharpton, who got 4 million to stand for, to say that this was all good for diversity, they call him a fraud. They say he's not enough into the industry that we are to be credible enough for his letter to be worth anything. Do I understand that correctly?
Right. And what's important here is that he sued not just Comcast, he sued Al Sharpton, the National Urban League, the National Action Network, and the NAACP.
So he sued them for not being pure enough into the diversity industry and for not standing for what they describe as 100% African American owned media businesses.
Right. For essentially conspiracy. He invoked an old sort of law for it, but it sort of dovetails with disparate impact because that was how he established.
Is it the good old civil conspiracy?
Well, what he's saying is that their actions were, in totality, they were racially discriminatory against 100% Black-owned business. And the idea is that these multinational corporations, Comcast, AT&T, CNN, and Starbucks, pay the NAACP, they pay the National Urban League, they make these donations in order to secure their support for regulatory approvals, for protection from racial lawsuits, and for affidavits of good character and for awards. Now, if you remember, within 48 hours of this incident happening with Starbucks, remember who Howard Schultz, the chairman of Starbucks, hired. He hired the president of the NAACP, Sherilyn Ifill. He hired Brian Stevenson, with the head of the Equality Directive, and Heather McGee of Demos. Basically, all of these, the most expensive money you can get The head of the NAACP over someone calling the cops at a Starbucks when they were loitering. But this is the same thing. They are buying it not just as litigation insurance, but also this is going to pay for their influence on city council, because that money funnels down into local and city politics, and it's going to protect them from these lawsuits. One of the things I can pull up if we have time are the rebuttals to these various plaintiffs' complaints. Like the responses in every single time will mention the awards they receive from from the NAACP and the National Urban League and Al Sharpton, all of their awards, how long they've been in business with them, and there will be basically amicus briefs filed to protect them, so that you essentially have the head of Black leadership saying this organization is not racist. Now, not only is that a defensive weapon, but what that does is that is also a way of boxing out competitors from your geographic area. Because one of the things we're going to get into is government contracts and how money gets funneled into these various organizations to create what is essentially a soft cartel that other groups can't come into your turf because they haven't paid off the diversity groups who have control over zoning, who have control over regulations, who have control over racial discrimination pressure.
There's not much difference between what you described there and the mafia going around town when I was young and saying, look, you might very well catch fire if you don't give us a $100 or $200 insurance every month.
Right. It started as a shield, but it's become a sword. And we'll get into that in a bit. But let's move on with some of the rest of this. So here you see on, I think it's 2 slides later, here Byron Allen brings another lawsuit, this time against Comcast, for how much? $20 billion.
Holy
$20 billion, right? But this case survived summary judgment. This is more than any corporation can afford, and you will have to be litigated in court. And if you get a shitty jury, people who just want to see your soulless corporation get taken down a peg, you are at the arbitrary whim, essentially, of a few people who may just have a racial animus against you, and in which case that could be a bankruptcy event for even the most well-to-do of companies. And as you saw, many of these companies, like Abercrombie, died basically in 2004 after that racial discrimination lawsuit. These are bet the company cases.
Wow.
So let me just go through 1 or 2 more slides, and then we'll take a pause.
Okay.
There is a good write-up of the next topic that we're going to talk about, which is no defense, everything is illegal, in the following link that I just sent you in the lobby. And this is actually a book by Jared Taylor, of all people. The book is called Paved with Good Intentions. I encourage you guys to support American Renaissance to the extent that you feel it's appropriate, but this is just a PDF for purposes of this presentation. And if on page, can you turn now to page 157, the bottom of page 157?
Just so I know, is that a book?
Yes.
Because if it's a published book, I will not show it on my computer.
Oh, okay. It is. I have a link to the relevant passage that's on the slide before the one you're at.
All right.
And I can read it if that's,
yeah, if you can read it, that's better. It's okay to quote, but I wouldn't scroll through the book since there are copyrights issues.
That makes sense. That makes sense, and I respect that. So here this is now on the topic of racial sensitivity and how every little thing you do that may or may not be racist can be used against you in a court of law. Here is, all right. So, all right. Sorry, one sec. Yeah, 157. Okay. Okay. So in 1985, under the prodding of officials appointed by President Ronald Reagan, the U.S. Justice Department tried to abolish the requirement that government contractors set minority hiring goals. Discrimination against non-whites would still be illegal, but trying to get rid of the affirmative action. I'm sorry. Hold on one second. I think this was the passage I was trying to. Let me just run a quick search. Okay. All right, so this is basically in 1990. I'm skipping ahead a little bit. A California transit executive took part in a transportation study group, and in arguing that some of the beneficiaries of racial preferences in hiring were not adequately qualified, he reportedly used the expression, quote, inept minorities and women, end quote. Man was suspended from his $90,000 a year job and was given sensitivity and awareness training. Basically, they hired a third-party diversity emergency consultant who charged them basically $275 per person at the company. And at this workshop, employees were asked their responses to a number of dynamics related to sort of white and black ethnic issues, and they replied candidly. The employees did. The
Never reply
words of
candidly.
well, what happened was a court of law found that the transcripts from these racial sensitivity workshops could be used as evidence to show systemic discrimination, systemic bias at the company. So this company, which tried to do the right thing and hire a diversity company to run racial sensitivity training, because certain employees said things that were perceived to be racist in the racial sensitivity training, the employer was held the testimony of the employees was held was shown up in court to be evidence that there was systemic discrimination. So even if you try to do the right thing, and this has since been semi-remedied through the use of confidentiality agreements and various other sort of legalities, but there's really no way to do the right thing here.
And it gets
And one
under
other
the
point,
hearsay exception, I guess, because it's a document produced as part of a regular corporate activity.
well, right. I mean, everything, the whole premise of disparate impact is to get the dirty underwear of the company because of the allegation that you'd never really know if the company is racist until oftentimes it's really hard to prove disparate treatment. It's really hard to show that somebody was racially biased against you. And so by surviving summary judgment and getting into the discovery process, you get all the emails, all the text messages, you get basically all the company documents that that you can cull to find out whether or not there was any racial incident, and any individual one can result in bankruptcy, which is there's a famous case of one employee sending a meme of an African child dancing, and it was a vice president who sent it to his wife saying it's Friday, and then the N-word with a soft A, but it was just like a meme to say like we're celebrating that it's Friday. But this meme ended up costing, let me see the exact amount.
I was getting ready to mute you. I was like, please, Frame Game, don't do hate speech on my YouTube. And I really appreciate that you said N-word instead of the word.
I wouldn't. But this is actually, this is actually AT&T. And this is a case of, basically, AT&T had to pay out the butt for this. And for this guy sending a meme in private, right? Like, I think it was to his wife or something. Anyway, so now I want to just turn quickly before we pause for, I'll take a breath in a minute here.
And by the way, when Frame Games takes a breath, a lot of people on the chat are asking me to comment on the crowd DM thing. I will. There's nothing to be ashamed of in my exchange with crowd, so I will. But let's finish what Frame Game has to say.
Sure. So there's a case that I will. I'm going to send this to you in the lobby. It's called Ragan versus the New York Times, and there's also um, a similar case that was brought by the same plaintiff, Ragan. And this case is a good example of what I told you earlier about the requirement that there be that if you're doing business in a area with a significant number of black citizens, that if your display advertisements do not have racial diversity, then you could be on the hook for disparate impact liability. That could be deemed per se racial discrimination simply because your marketing materials have too many white people. So I'm going to give you the facts of this case real quick.
You gotta be kidding me, but go ahead.
All right, 1 second here. Let me just make sure I'm on the right page here. Okay. So, all right. Sorry, 1 sec.
I see that it's a district court case, so it wasn't pushed in higher courts?
Right. Right. Well, partly because I believe that it was a court-approved settlement. So, all right, 1 sec here. Sorry. Maybe I'll pull this up because this is its own sort of topic. So maybe I'll take my breath now and then we'll.
All right. So take your breath. I will be reading the super chats first, and then I will be commenting on this Kraut affair that people are talking about on the chat. I'll be happy to. 00 says pro-Israel Bucks lifted the strategy straight from rules of radicals. Cause a big stink is the strategy. Look it up. Do you agree with this cause a big stink metaphor, or do you think that this is what happened with Starbucks?
Well, that is certainly a key part of it. And, all of these plaintiffs' lawsuits also have a PR wing where they will, they'll take out advertising space. They'll rent, they'll rent ad space on taxis in the city to try to, gin up outrage. So that is a key part of it, certainly, but it's not all of it.
All right, Wasatchman is back on our super chats, and it's been a while. I'm glad to see you back. $10 US. He says, my assumption has been Starbucks staged the black kickout event in order to virtue signal at a corporate level and as an excuse to bring in the globalist re-education seminar. Viral marketing. I think it's a fair hypothesis. There's unfortunately no facts available that would allow me to say yes, that's true, or that's probably true. I think that there's no facts right now pointing to that hypothesis, but it's an interesting one. Strom McCallum, $20. Thank you so much. He says, Frame, check out the need for a democratic socialist Southern patriotic movement. That's the title of a book, I understand. Racialism and alt-right politics are not solutions to the problem facing the world. Left-wing nationalism is the only decent path forward. That's a strong statement. What do you think about that, Frame Game?
It is. Well, there needs to be an unwinding. And one of the white pills that we'll get to is that much of the business ecosystem that's developed it hangs on by a very thin thread legally. And if certain legal precedents can be tossed out, you might see a cascade of business practices overturned in the same way that it wasn't until these were codified into law that the business cascade started the other direction.
On left-wing nationalism, I will say I don't object to left-wing nationalism. I think it's very relevant in certain countries. In Quebec, the nationalism is left-wing, it's not right-wing, and I would join that movement if I thought that the independence of Quebec is more important than the question of right or left. However, in America, I think that the only hope is right-wing nationalism. Because of the configuration of the policies, because of the liberty lovers and the people who respect the Constitution, they happen to be right-wing. But I don't object to left-wing nationalism in other circumstances. However, deeply, I am a right-winger. I am for liberty. I am for small states. So that's my comment on your super chat. Uh, Now we have Robert Paulson saying, was just going to ask, how could disparate impact be constitutional? But Frame Games already answered. Please hold all questions until the end. Mike DC100 says, wow, litigious hustle steeped in cultural Marxism. Yeah, I mean, you see, when I hear Jordan Peterson, Sargon of Akkad complain against cultural Marxism, I think I'm with them. But when I hear Frame Game explain to us, look, cultural Marxism or whatever, if we want to put the label cultural Marxism on these things, whatever you want to call these things, the diversity industry or cultural Marxism, they've been they've been at work for decades and they've won cases and they use these cases right now to change society and to bully companies into doing very unproductive things. DP says Dodd-Frank helped the biggest banks consolidate power. Alexander sends us $100 US. Thank you so much. And I don't know if you're the same Alexander who sent me a PayPal donation, but thank you so much to the person who sent me a wonderful PayPal donation a few days ago. Could it be argued that any company that goes public will always have to capitulate to the PC culture simply because they are not concerned with integrity but the long con? I think this is along the line of what you think, Frame Game, right?
Yes, well, and we've barely gotten to the tip of the iceberg here. I mean, we're going to cover some other topics here that are going to, I think, persuade a lot of minds on this. But I do want to just remind people that there is a white pill here about the constitutionality of all of this, which is that there was a major case in 2009 called Ritchie versus DeStefano that has struck fear into the hearts of the civil rights plaintiffs bar. And now there has been a concerted effort by the bar, by plaintiffs, to not let the Supreme Court revisit this issue because of how close that case came to overturning disparate impact.
Okay, so they don't want more Supreme Court decisions.
Right.
Yeah, I mean, I think that ultimately what we will need is a white guy entering some shop where he gets rejected and just using that system and raping it up to the Supreme Court, up to the point where we will get all these decisions cancelled. I mean, it's a dream, it's a pipe dream. I don't know if it will happen, and it might take decades, but we'll essentially need male guys to go into female clinics and say, I want to get served. We'll need white guys to go into whatever shop where there's only black people and say, I want a job. We're gonna need very stubborn autistic white guys just pounding through that system and exploiting it until it's totally on the ground and it doesn't exist anymore. Mike DC says, let's see Tariq Nasheed spin it as white supremacy. Peace Lily sends us $2. Thank you so much. Jake Jorgensen says, Frame Game, my Twitter got suspended, so I have to ask you here. When are you going to write a book on all this material you cover with JF? You have to do this. You can't get this material anywhere else. That is true. What you provide here, Frame Game, is so original, it would definitely make a book.
That's true. I want to first focus on trying to get the story out. I mean, there's the difficulty in organizing it is tremendous, and I also think that a book may not be the best medium. I love to write, and I'm sure one day it'll happen. But in the meantime, I'd like to produce video content because I think that is where persuasion has moved with the younger generation in particular. So I want to make sure to get video out first before undertaking a book.
All right, wonderful. Robert Paulson says, Frame Game, quote, if only you knew how bad things really are. Radio. That is true. Frame Game is the one who, even I, as a moral nihilist and as a guy who considers that he can take any hit, I have to say the hits that Frame Game give, he has some good punch about how society has turned, and I didn't know these things. Oscar DE says, "Hi Jeff, check out Stitcher.com. It is an audio platform where the big podcasters, Rogan, Moliner, Peterson, have their audio content uploaded. Keep up the good work. Greetings from Germany." I believe I've known Stitcher when I was young. I didn't know they were still doing stuff. I'll try. I think I uploaded some of my very early stuff on there. I would have to have a look if it's possible to upload our podcast. I guess you guys could get it on your iPhones, and you guys could get it in a different way than YouTube itself. The Vicious says, which way do you prefer donations? Through this, or also those permit patty stories could be staged? Well, the answer is, if you feel like giving super chats, go for it, because the 30% that goes to YouTube, I'm actually happy about it. It's like I want YouTube to say, what the fuck is happening with this French guy? He's making he's making us thousands of dollars a month. We can't ban him. What the fuck is happening? Where other YouTubers are doing much less in super chat on average. Even I was looking at, for example, TYT, 9,000 watching live. They didn't make a single bucks through super chat. Now I understand that TYT has a separate money pattern where they ask people to give on their website. However, I want YouTube to know that I'm bringing more money to this platform than Anna Kasparian. And so think about it before you mute me, and think about it before you censor me. All right? Because your little employee, your little cute secretary at Google who gets paid $30,000 a year, that's me. That's my audience that's paying her salary. So enjoy it, bitches, and don't censor me. uh yeah, then I need to comment on this. Yeah, but if you want the most money efficient way to send me money, you can send Bitcoin, you can send PayPal. If you have a great amount to send me, you can go for it, but again, I'm happy that YouTube is making a part of it. So the Kraut story. So there's a YouTuber, I will not name his name because he's retarded, and also because he's attacked my family in the past, and so he's on my blacklist. So I will not name the name of the YouTuber, but he goes around and claims that he has DM of me and Kraut, and that it exposes some operation against Sargon that I would be the part of. What I say to anyone who has DMs from me, these DMs are public. I don't do secret planning. And so publish my DMs, Kraut. Publish my DMs, Mr. YouTuber. I don't give a shit. Anyone who looks at these DMs will conclude JF is acting pretty morally when he's in private. And you know why? That's because JF doesn't even have a concept of privacy other than my little home and my little family. And so I have no shame for anything I've said about Kraut or to Kraut in any sort of DM. So go ahead, publish them. And for those of you who want to know what I was saying to Kraut in these DM, you can go watch my video about Coach Red Pill. The video was titled Sargon Must Retract. And as part of the investigation following up on that video, we had various hypotheses about the involvement of Sargon of Akkad in the CRP doxing affair. And these hypotheses have not been resolved for many months. And so I went to Kraut and I asked him, hey Kraut, do you have information about all this that you'd like to share? Please share them with me if you want. And you'll see that this is all that there is in my conversation with Kraut. I'm not part of any team that's looking to take down Sargon. I'm not part of any conspiracy. I'm a journalist. I do YouTube videos, and I do follow up when there are unresolved hypotheses and undenied facts. There are some people claiming stuff, and we don't have a denial from Sargon about some information that would implicate him in the Kraut affair and the doxing of CRP. I will keep asking to everyone around me, as a good journalist would do, hey, do you have information about this? Hey, do you have information about this? That's my job. Get fucked, YouTuber. All right, Frame Game. Did you catch your breath?
I sure did. So the next topic I wanted to get to, is the field of affirmative marketing. You probably might not know what that is. You know what affirmative action is, but you've probably never heard of affirmative marketing. But affirmative marketing is the field of basically affirmative action in marketing materials requiring racial representation that does not have too many white people. I would like to say that it is it's about racial equity and trying to represent the jurisdiction's demographics where you're doing business. That would at least be potentially defensible, but it's simply not that. It is only and always anti-white. I don't know of a single instance of a white person drawing protection from affirmative marketing. If you doubt me, I dare you to put into Google right now, in quotes, affirmative marketing, and end quotes, and then racial representation or something. I'll show you. I'll just show you in the lobby a quick example of this, JF, and then and then I'll move on with some of the material here. I just sent you just a sample thing in the lobby.
Affirmative marketing is an essential tool in the federal government's initiative to provide affordable housing in cities across the country. Blah, 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 doesn't create requirements for affirmative marketing practices.
Right. Well, I mean, if you pull up the link that I show you, what you'll see is that this is all soft. And that's part of how a lot of normies don't know about this, is that often to receive money from the HUD, the Housing and Urban Development, or any of these other organizations at a local or state level, you will have to devise an affirmative marketing plan and make sure that you have affirmative action marketing materials. I want to read a summary of how this plays out now. So let me just read about 3 paragraphs here for you. Real estate marketing advertising has resulted in an unanticipated form of quota hiring for Black models. An organization called the Leadership Council for Metropolitan Open Communities has sued at least half a dozen Chicago area developers for not running Black models in their housing ads. Most cases have been settled out of court with cash and with pledges to use Black models. The developer need not have discriminated in the slightest. His advertising was held to be discriminatory. This is in the Ragan cases, Ragan versus North Shore Towers, Ragan versus New York Times. Although it would never occur to most people that advertisements must show a certain number of Black faces, that appears to be the law. The owner and agent of a New York property called North Shore Towers was ordered by a U.S. District Court to pay $245,000 to 4 Black individuals who claimed they were discouraged from trying to live there because the company's ads featured only white people. The owners were also ordered to run 97 ads over the next 4 years at an estimated cost of $200,000. This is a court order. 75% of the ads had to have Black people in them, and 1/3 of the people total had to be Black. This is a court order, JF. This is the law of the land. Owners were made to pay. Owners were made to pay not for discrimination, but simply for inappropriate advertising. The situation is even more surprising than this. In 1991, the U.S. Court of Appeals for the Second Circuit ruled that the New York Times could be sued because it accepted real estate ads that did not depict enough non-whites. A Black couple, along with a Manhattan fair housing organization, charged that since the Times so rarely featured Black models in its real estate ads, it was violating the Fair Housing Act of 1968. The Cincinnati Enquirer has a similar case on appeal in the U.S. Court of Appeals. I'm not sure how that turned out. The Washington Post has settled the 1988 lawsuit by promising to use Black models 25% of the time in real estate ads. Soon thereafter, 22 Washington area real estate developers, sales companies, and ad agencies had to agree to use Black models 33% of the time. So it's not just you as a company trying to do ads, it's you as a platform hosting it by perpetuating it. This is how they get you, similar to like hosting something related to hate speech.
This is such a red pill to me because I'm kind of like the normies who approach this, and they think, and I used to think before I heard about it from you, that companies, they self bully into putting the token black guy or the token transsexual host on MTV, or these token people. They're actually requirements of the law.
Yes, and in fact, they're often the settlements that usually this is one way that a company can avoid getting really destroyed in PR or in court, is to they figure, all right, what does it matter? I'll just diversify my marketing materials. What does it matter? What does it matter? And they give this, or at least that's what it was 20 years ago. Now that is settled essentially, and it's something that there's a number of cases I could get into that relate to like online advertising companies that whenever they get sued for racial discrimination, they need to throw up in their affirmative defense how much overrepresentation they have of minority and women. But basically, they need to have that for protection in their own industry as well. So the whole thing is top to bottom. Your hands are pretty much tied. If you don't do this, you could lose everything that you spent your life trying to build. I mean, you saw the size of these settlements. These are hundreds of millions of dollars, and you can't dismiss them. So, all right. So let me move on here. And if you're curious, I sent you that link, that justice link there. But before we, so in the next slide, I kind of have a gee. Is it any wonder that McDonald's now posits itself as a modern and progressive burger company, that YouTube
Do I access
says,
this slide by our history, and what number of slide is it?
Yeah, it's the second to last slide.
Okay.
And in fact, we can just go right to the last slide, which is a case I want to cover, which is the white pill, and a merciful one. Remember that all of the diversity industry that we've seen commercialized over the past 60 years grew out of one act, the 1960 Title VII of the 1964 Civil Rights Act. If you take that away, everything else crumbles. All of these things that are mandated by law become illegal. So all it takes is a favorable Supreme Court to set in motion the undoing of so much of the Hydra heads that we see here. But let me tell you now about a case called Ritchie versus DeStefano. It was, I wish I could play this audio, because this gentleman does a great job of explaining it in a really honest and fair way. In fact, I can send you the YouTube link from the source video. I have it. Hold on one second.
So Ritchie versus DeStefano is a U.S. labor law case of the United States Supreme Court on unlawful discrimination through disparate impact under the Civil Rights Act of 1964.
Yep. And I have the, I think I have pulled up here. I have all the YouTube clips, actually. Let me do that at the end of the next section. I'll just pull them up. We can just go bam, bam, through them all
right.
At the end of the next section. So basically what happened here in Ricci is the New Haven, Connecticut, I believe it was their firefighters, their local firefighters department they were afraid that they didn't have enough black firefighters and that white people were hugely overrepresented. So what they did is they hired a very expensive diversity consulting organization, the likes of which you'll get to know over the course of the series very well, to basically do an audit of their policies and to come up with a new test where black people and white people would score at relatively even rates. That way, it would relieve them of a disparate impact liability. And they were afraid because the LA and New York had just had $100 million settlements, totally destroyed the city budget with these cases. So they bend over backwards and they have this new test, and they're really optimistic. It's really going to be equality here. And it turns out that the test is only passed, I think, by the highest people who scored were like 17 white people and one Hispanic person. And it resulted in the same kind of disparate impact that they were afraid of before they redid the test. So so what they decided is they were not going to promote these firefighters, these white and one Hispanic firefighters. Instead, they were going to try to do a new test all over again until they got the numbers right. And what happened was the white firefighters and the one Hispanic firefighter sued the city of New Haven on the grounds of disparate treatment. That is, not disparate impact, but disparate treatment, saying that that what they did was unlawful. They were discriminating purely on the basis of race, and it was a moment where the Supreme Court could have abolished disparate impact forever. But
Yeah,
what they
that's
chose to
essentially
do,
the white guy that I suggested earlier, taking it to the Supreme Court. That would be a white pill if he won.
right? And there was no dispute over the facts here. I mean, the New Haven was very. In fact, they even said in court, "Listen, if we didn't do this, we'd be liable under disparate impact. So, we're damned if we do, damned if we don't." So what the Supreme Court did is it ruled that that you needed to make a specific showing with respect to disparate impact, and that the mere fear of a disparate impact lawsuit alone is not enough to racially discriminate against white or against predominantly like white men. So it's a very, very it's a middle of the road sort of ruling, and what it basically says is you can't have like a hard quota system, and you can't discriminate on the basis of race purely because you are afraid of a lawsuit that makes you. I know you're making that face, but that is the narrowest reading of the case.
Yeah, no, I mean it's a weird case. It's very weird as a decision. They could have. It's another case, just like the bake the cake decision. It's another case where the freaking U.S. Supreme Court plays autistic. What the fuck are you doing? We're paying you millions. Just do the job. The people of America want to know what's the state of affair, and the main question being, is it constitutional to refuse to bake the cake, or is it constitutional to discriminate against white people if you have quotas? And they keep getting away with it with autistic details that no one cares about.
Well, yeah, I mean it's actually a lot more gruesome than that, right? Because there's the only real way to interpret the law is that white people do not have this cause of action available to them. And that's one of the things I was going to show you in the video compilation that I put together, which is that you have a number of professors who have taken this position, and teach, and this is one fairly solid interpretation, is that if white people were able to bring disparate impact cases, then it would be subject to what's called strict scrutiny, which is a legal standard for evaluating constitutionality. And the evasion of strict scrutiny, which means sort of narrow tailoring, is the thing that has kept this this Hydra head alive. And there's a number of cases that have come out in the past couple of years that I mentioned, where the civil rights activists have intentionally settled cases for next to nothing right before they got to the Supreme Court, because they were, quote, bad facts. So there's this philosophy that bad facts make bad law. If it's a particularly egregious case, you could have a precedent set that would undermine disparate impact for everyone. So there are a bunch of cases on that that I could list off for people who are interested in pursuing it. So let's that is sort of the white pill. All it takes is one good case, and you could have a new 1964 act that abolishes the 1971 precedent. That alone would absolutely decimate the Hydra head we're going to turn to now. So before I get to the next section, do you need a pause for super chats?
There's not much new, but I can read those that have appeared. The Vicious, I read this one. Fernando Covet, who's John Gold? I don't know who that is. Is it someone you named, the Frame Game?
John Galt. Oh, that is John. Who is John Galt? Is the calling cry of Ayn Rand's Atlas Shrugged. John Galt was the guy who basically stopped the motor of the world by getting all of the responsible businessmen to back out of society. It's basically secession. They went to Gulch in Colorado, and then the rest of the world just basically, begged for them back because the wheel of commerce stopped.
Okay. So-called Justice Wire says, I am just the stubborn, autistic white guy you need. My boss is a black woman who frequently violate OSHA regulation. She never disciplines blacks either. Well, good luck, so-called. I mean, I can't give you legal advice, but good luck. Robert Paulson says, $2 for YouTube. Shell Beach says, don't write a book, make a full-length documentary. I think that the Frame Game reports, in a way, they constitute a good series, and that's why I featured it at the top of my channel, because I think the videos you make, Frame Game here, they are timeless. They will still be watched in a year from now, so that's why I featured it at the top of my channel for now. The whole list of the Frame Game reports, a very in-depth look at the questions of diversity and of white identity. I've never seen something like that. Frederick White says, FHA destroyed ethnic Catholic communities. Josh Milo says, Frame Games, do you identify as Jewish or white?
I mean, this is a tough question, obviously. I mean, I'm a normal human being with a normal life. So because of that, I identify as both, and selectively, unfortunately. But I try not to use that against people who are trying to promote positivity with white people, right? I mean, I say that I'm white on census data. I acknowledge that there are differences between me and sort of Gentile white people, but I try to use it for good. But I'm both.
All right, Ryan, $10 says, Jeff, can you do a stream with congressional candidate John Fitzgerald? He openly talks about Israeli involvement in 911. He was on the, I always say 911. People tell me it's 9/11, Jeff. All right, 9/11. He was on the Realist Report podcast earlier this week. All right, I'll have a look at him. So, Frame Game, we are ready to go on the description of the Hydra. I'm scared.
Okay, well, first, just for fun, I in the lobby, I just sent you that like 1.5 minute clip. I have the start time included in the link. It starts at 41:56 and it plays until 43:49. That's the clip that I wanted to start out this talk with. It's for fun, but it's true.
All right. Oh my God, something is wrong with YouTube. YouTube is refusing to send me any video. It's like I can't load videos. Maybe if I try in a different browser?
Yeah, or if you just type in use of disparate impact analysis 11/15/2013, you can scroll right to it.
For the first time of my life, I'm looking in my start menu for Microsoft Edge. Ugh, I feel dirty. Maybe it's just a problem with my browser sending too much stuff and sending the live stream itself. Oh no, really, nothing plays in YouTube.
So just for fun, JF, since you're turning to Microsoft, I haven't even looked at this in advance. I just type in Microsoft racial discrimination lawsuit.
Oh yeah, you have to give us the EA lawsuits, whether they're exist. Okay.
I'm confident. Okay, so here you go. I just looked up Microsoft just while you were doing that, and here you go. 2001, 6 plaintiffs joined $5 billion racial discrimination lawsuit against Microsoft. $5 billion for 6 people.
Wow. Discriminated against African American employees who made valuable contributions to the company but were not treated with the same dignity, respect, and compensation as their white counterparts. That is a big sum of money.
$5 billion. So yeah, I think that's worth flying into Philadelphia for, right? Why do they do it? Yeah, I'll send you I guess you have the name of the thing if you want to look it up, but I'll move on with the presentation in the meantime.
All right.
So it is in the section called the New Evolution, and I want to cover 3 things real quick. 1 are federal requirements. 2 is the greatest affirmative action program hold on a second. That's not it. It should be called. Maybe you need to refresh. It should be called the new evolution. And do we not have the same version?
You may have sent me a past version because I didn't have your last slide about McDonald.
Okay, that's fine. I will. I'll just go through it on my end. And I'll send you the relevant links.
Here I refreshed it. Maybe if I click on the new evolution. Yeah, there it is. But it was not refreshed.
Okay. So now if you go on the double click below, so we're going to cover a few of these here. So if you want to do business with the federal government, here are, in fact, I'll just pull it up so that you have it. It'll be easier if we just do it this way. I'm sending you the link now for so that you understand part of how the diversity industry evolved was that at every level of government, if you want to have a contract with, basically city, state, or federal government, you need to have an affirmative action plan. That's not like it's best practice or maybe you should, maybe you shouldn't. Federal government contracts are a $500 billion economy. That's $500 billion each year that the federal government alone gives out to subcontractors to do work for the federal government. I'm telling you this because we're doing a little bit of a market sizing so you understand how business has been wrapped around this. And most government agencies who target basically a 20% allocation to women and minority-owned businesses as a portion of that, often with like 7%. So one standard is like 7% to minority-owned businesses, 13% to women-owned businesses. It varies a little bit state by state and federal agency by federal agency. But just so that you understand this, I'm going to first show a link here. This is just some HR best practices. This is just from Monster. And what it's going to show you is the mandatory best practices and how you need to have an affirmative action plan complete with your goals and milestones and basically the same thing that was put in place in all of those racial discrimination lawsuits in order to have any government contract at all. That is, I think it has to be if it's more than $10,000. So you have a $500 billion industry where every single person has to have an affirmative action program that has goals and milestones for reducing the numbers of white people. So, just so you understand what this looks like, here's a little Department of Labor, sample affirmative action plan. But these things take hundreds of hours to compile, and then you need to go through your civil rights or labor attorney to bless it. And what it is you basically have to take racial stock of your company. That is, remember, this entire $500 billion economy. You have to take racial stock of your company, and you need to basically account for every single person and take measurements of how over or underrepresented various people are. And when you have something that falls below, say, the 4/5, you need to have an affirmative action plan that has specific, basically quarterly and annual goals to get rid of the white people so that your numbers are right.
Wow.
So now that's the federal government alone. I'm going to play. If the YouTube links work here, I just sent you a YouTube link here. Maybe you can copy and paste it into Microsoft Edge. And
I tried Microsoft Edge. It wasn't playing. But it seems that everything I try on YouTube, it seems that YouTube has kind of barred my IP or something like that. I don't know.
Okay. Well, I was going to show you a sample of how, for example, this is just Massachusetts state. And this is like a 45-minute compliance video. And there's 3 minutes here. If we can post it in the chat for people or in the links below afterwards, so people can see this. But between 2 minutes and 5 minutes, it goes over the overview. And basically, if you want to do business with Massachusetts State, I don't care if you are a lender, if you are a NGO for housing, if you're an NGO for, if you're helping homeless people, if you are whatever, however you're doing business, parks and recreation, you name it, you need to have in your bid to the state government how much money you are paying to minority-owned businesses, and you need to set a specific target and write basically an essay about all of how you're going to track this and what you're going to do if you don't meet your threshold. So you need to say up front how much money you're going to pay into the diversity industry, and then hold yourself accountable to it. If you want to, I don't know, get money for studying squirrels in some local Boston park, it is that extensive. So
this must represent huge diminutions of production. This makes me think of us at Duke University when we were doing monkey research. They were starting to force labs to use 50% female monkeys. I'm not kidding. We were doing surgery, and the males were important to our work because the males, they drink more juice, they want more bananas, and so they play computer games more. The male monkeys were the best to play computer games, but we were forced to use 50% female.
Yep. Yeah. Well, I mean, that's par for the course here. So one of the things that has propped up as a way to sort of protect the executive boards, but still comply with paying off the diversity industry is something called the diversity supplier programs. Diversity supplier programs have been they are affirmative action for businesses, so that at every point in a company's supply chain, you are preferring non-white business owners to white business owners. So if you go to the next slide there, it shows some examples of this. And also, I just posted this. I'm sorry, it's the one after this. You can check out nmsdc.org if you'd like. Because you need to give money to Black-owned businesses to do business in the United States now, there has become a competition to be a Black-owned business and to be officially certified as Black or as non-white. And
this sounds like the organics industry. It's like you have to keep paper of everything you give to the cows. You need to know every seed, where they come from, every egg, where they come from. And now you have this certification for Black-owned businesses.
Yeah, well, it's awesome how they actually certify you. It's like it's an achievement in and of itself. They actually do on-site visits to make sure that you are that. So here, if you go back to the slideshow, I'll show you some relevant slides from the site so that you understand the ecosystem here. I think if you click on supplier diversity programs.
Supplier diversity programs.
Yeah. All right. So if you zoom in there, here is it's back one.
Oh, the one before?
Yeah, it's the one before this.
Okay.
So this is just a quick hit list of some of the people who have sworn to, it's basically every company you've ever heard of. Apple, Google, Microsoft. I mean, any company who's any company. I just did the work for you guys so that you can see
Walt
literally
Disney, Walmart, Viacom, Macy's, McGraw-Hill, McGuire Woods, Morgan Stanley. Yeah, very big companies.
Everyone, they all have pledged to basically have a certain percentage of their supply chain go out to only Black-owned or woman-owned business. And in various proportions, depending on what tier of membership they are. Now, here's, so remember, there's this whole, at least at least several $100 billion industry here where you need to get licensed to be Black or a woman. Now, check out some of the criteria here. Can you scroll and look at the criteria for getting certified as being a black
Yeah.
or
Criteria
so?
for certification, United States
Okay.
citizens.
Now here's something that's very important to understand how the puppetry that goes on here. That this is all okay. So minority businesses must be at least 51% minority owned and controlled. For purposes of NMSDC's program, a minority group member is an individual at least 25% Asian, Black, Hispanic, or Native American. A minority eligibility is established via a combination of screenings, interviews, and site visits. Ownership means it's at least 51% of the stock. Now, so one of the things that is, and there's more in the certification section that's pretty amazing. But basically, you only need to be 25%. I'm sorry. One of the things I didn't include it in the slide is that you need to be at least 51% minority owned and controlled, but you need to be only, I think, something like 25% or 10%, of the economic interest in the stock. So basically, you are allowed to be less than 51% ownership if there's a class of stock that's just basically your daddy Warbucks. So
Wait,
this
this one is
is
hard to understand. What's the Daddy Warbucks reference?
so I'll pull up the here you go. I'm gonna. It's right here in this link right here, nmsdc.org, the MBE certification, Minority Business Enterprise certification. So you'll note that what it says is that you need 51%. Basically, Black-owned businesses or minority-owned business racial minorities have to be at least 51% of the voting equity, but not the economic equity, meaning that you can still be a Black-owned business if most of the money, most of the economic rights to the company are owned by white people. Do you understand? There's
So
this carve
let's
out.
say you have 7 chairs on the committee that controls the company. You have 2 rich white
Yes.
guys who fund most of the money of the company, and then they have to sit with 5 kind of honorary chairmen that would be from minorities, so that they would respect that, but they could be the ones who still making the money, the white guys.
Yes, they could be making, like 90% of them. I'm sorry, there's at least 30%, right? So here it is. If you pull that back up, basically non-white people have to own at least 30% of the economic rights. So basically, you have all of these shell companies, and I know because I've represented them. You have all of these white and Jewish people who prop up these, minority owned businesses where they own 70% of the economic rights. But this carve out exists so that they can make money from it. Like it's so that if they really cared about it, then they would say the racial minorities need to own at least 51% of the economic rights. But no, 70% of it can be owned by white or Jewish people, and it's still in compliance.
We're gonna raise a whole generation of minority members who will be yes men to bigger investors than them. Essentially, their job will be to sit on a chair and do whatever the 70% white owners want and say, and they'll just be giving their voice as a minority to fit these criteria.
Well, right, because remember, there is a shortage of funds. If they're in a free market, the money would go to the best competitor anyway, and it would be stupid to racially discriminate because the person who does the best job would do it for a cheaper price, and the company who doesn't discriminate would win. So what you have is you have all these companies who are stuck with needing to basically do business with like black owned or a non-white or women owned businesses, and what they do basically is they get around it through partnerships. These are part of the community partnerships that I've talked about, at length before, and I will show you Starbucks' website where it goes through all of these. But this is how they prop them up. It's basically they maintain control because they maintain basically the economic rights, and then there's kickbacks. It's almost like a super chat. It's like a 30% charge the diversity industry gets. But now you get the federal contract or the state contract, the local contract. So this is one of the ways that this is co-evolved. So I'll show you an example of this in the next slide, but I can just send you the link so you don't need to go back and forth to it. Here is the $1 billion roundtable. Now, I just sent it to you in a link to it in the chat. In fact, I will send you all 3 links here. And you will notice 2 things right away. 1, this is a shitload of money. And 2, this website looks like it's maintained by a 5th grader. Not this one, but the next 2.
No, but I was about to say about this one. Sure. Are they bragging about it being a $1 billion roundtable?
No, what they do is these are tier 1 companies that get special benefits in the diversity industry by pledging at least $1 billion to diversity causes annually.
Oh, it's an elite club.
Right. Mm-hmm. This is how you buy the NAACP and the National Urban League and the Al Sharpton National Action Network. And look at the $1 billion roundtable brags that 70 through this one program alone. Remember, I told you it's over $1 trillion in the U.S. annually. This single program alone is $77 billion. That's not the federal contracts. That's nothing. Okay, but go ahead. Click on the second link that I showed you in the.
I'm already crying. Thinking about all these billions.
And here you go. Look at this. Look at this multi-billion-dollar website. Oh yeah, 77 billion. Yeah, they're not bringing their best and their brightest, right? Like, this is part of the sham of it all. It's like they can't even. So and the next link sort of does the same thing, but you'll see it basically just checks out there. So the next thing that I'll show you on the agenda here, and of course they do awards, and remember that's part of how Donald Sterling gets his awards, and even like Donald Trump gets his awards and all this stuff, right? You pay for it. If you're a tier 1 member, you get the awards. Those awards buy you access. They buy you litigation defense, and a whole host of things. They buy you compliance, and they buy you influence with city councilmen and people who represent non-white constituents on everyone from the Civil Rights Office to the Department of Justice to HUD, all the way up and down the chain. This buys you Maxine Waters and all the other folks there. So, a particularly virulent strand of commercialized racial politics that stems out of the diversity industry comes from a new initiative called CEOaction.com. So I just sent you the link, but you can just type that in. And if you go to it, what you will see is the new. This is the new pledge. So it used to be the case that only the sort of pioneering companies for diversity would enroll in the NMSDC and do a supplier diversity program. Now it's the cost of doing business, right? It used to be the case with diversity workshops that only the sort of frontier ones, and then it becomes the cost of doing business. So what happens is the cost of doing business keeps on going up, and so now the new thing is this pledge. It's a lot like, the Israel pledge that we covered. And what this is, pretty much every major Fortune 500 company CEO has been strong-armed into signing this CEOaction.com, which however unwilling they may have been at first, it is now a business necessity. because if you don't sign it, it is taken as prima facie evidence that you are not in good. You're not conducting corporate best practices with respect to paying the diversity industry its due. So if you pull it up, what you'll see with the CEOaction.com is
I
just
attempted
you know
something very
oh,
wild, never tried in live streaming. I've reinstalled Adobe Flash Player in the hope that this would
wow.
fix the YouTube reading. However, I need to restart my browser. So, what's the link you want me to try? I will just close all.
It's just CEOaction.com.
All right. CEOaction.com. We'll try to open another browser. Now this is the most risky decision I've ever made in live streaming. Reinstalling Adobe Flash Player. Who knows what depends on this shit. Okay, CEO action. I have it here. Oh, now I have a black screen. What? My display capture was relying on this? What? How can I have fucked up my monitor read? What if I add it again? Window capture. Sorry for these technical difficulties. Microsoft Edge. Ah! There's 15 windows to choose from. Which one is it? Ah, failure. We have a black screen. I'm so sorry, Frame Game.
Oh, that's all right. So, I mean, I'll explain it to you. So, basically, the list is up to now 450 plus CEOs. Starbucks, everyone else. All of the major, most of the major Fortune 500 companies, their CEOs have signed this. And what this is an unconditional three-part pledge that in all of their multinational organizations they are going to implement. They're going to implement and expand. So here's, for example, point 2 on the pledges. We will implement and expand unconscious bias education. Unconscious bias education enables individuals to begin recognizing and minimizing potential blind spots. So basically, mandatory like white privilege workshops. And what this will also do is this will be a boon to the diversity consulting industry, which itself is something we haven't touched on yet, but it's something that bloomed beginning in the 1970s, which is that I've seen estimates that somewhere between 10 and 200 billion dollars are spent on racial and diversity awareness and bias training annually. Because remember, it's every single government agency at the national level, at the state level, at the local level, and every single employer with probably more than 200 companies, 200 employees. This is it's a mandatory thing, and you pay the National Urban League, or you pay the Quality Directors Initiative, or you pay the ADL to do this for you. So what this is you can think of it as like, by signing this pledge, you are promising a annuity to fund the diversity industry for forever after. And it's just one more source of income in addition to the supplier diversity, in addition to affirmative marketing, in addition to affirmative action, in addition to all the pipelines and all the other sort of special things we can get into that are now made best practices by the diversity gurus, which include having sort of Black only executive boards or non-white only executive teams, and hiring specific positions such as a provost or a vice president of diversity. So all of these actions are designed to entrench more and more, to make it impossible to do business without paying the toll to the industry. So I don't know if this is clear or if you're able to pull up the pledge yet.
It is absolutely clear. Unfortunately, I cannot even display Windows anymore. Look at this. I tried to display Google. I logged into Google. It shows as a white page. It's like my Streamlabs OBS has been bugged by my update of Adobe Flash Player, which I've done because I was trying to get the YouTube to work.
Yeah. Okay. Well, people can check that out. We can, a lot of the stuff that I wanted to do is sort of the multimedia stuff, but, we are what are we
But
coming
if
up
you
at, like
can
two and a half
share
hours?
screen, if you have things you'd like to show before leaving, we're at 2.5 hours, so we can end it here and make a part 3. But if there are things that you'd like to show in image, you can screen share. That I could do.
Yeah, I think this is okay. So let me hold on a second. Let me screen share real quick. I want to make sure I don't have anything open here. Hold on one moment.
Oh, there I go.
Oh,
I resuscitate.
you got it?
I have a resuscitation of my Google Chrome. CEO action is there. We will act on making change happen. Our CEOs in action. CEO action to expand reach and impact. Together we'll act on I keep reading them as they appear and I cut you. I'm sorry. Go ahead.
No, that's all right. That's all right. So, there's a number of interesting things that come out of this. First is, like with the supplier diversity program, which is now basically required, and it is required for any sort of state contracts, and like these other affirmative action programs, once it becomes, once there's a critical mass of people who sign it, it goes from being a way to show that you are not racist to being racist if you don't do it. And the bar just keeps on getting moved here, and it's very interesting. I think next time what we'll do is we'll go through the Starbucks website, and I will show you where each of these pieces plugs in, and the tension between Starbucks and their community partners who are so greedy and need to continually shake them down for more and more and more, which is now culminating in Starbucks trying to now do business in suburban areas, even if that means taking a 10% hit in their stock price, because in suburbia, you don't have these kind of shakedowns.
So in light of what we've seen today, how should I interpret this decision by Starbucks to close 150 stores? Are they saying there's too much troubles with the diversity community? There's no money to be made there?
I'm sorry, say that one more time.
So the closing of 150 stores by Starbucks and the refocusing on suburbans, is that essentially them saying the trouble is so big there's no money to be made there?
Yep, what they're saying, what they said on record was that it has become too expensive, and the regulatory approval, the cost of doing business has become too high, both because of regulatory issues, which they left fairly vague, and because of specific rules that are being passed in cities, such as ones relating to mandatory minimum wage and things like that. But what you see is that in order to do business there, they need to funnel a specific in order. They need to hit their targets. They need to have 20% of their supply chain go to Black-owned businesses, and those companies, and they have all the leverage. It gets to a point where your only leverage after a while is just to walk away. But what's really sort of evil about the whole thing is how the language now at places like CEO Action and at places like $1 Billion Roundtable and all these other ones is the very explicit language about white people no longer being an ethnic majority in the U.S. And this kind of musical chairs betting on white people not having as much discretionary income as other racial groups in the aggregate, and thus creating a business imperative beyond the legal and political imperative. And you see this language in a number of the videos that I was going to play, and on CEOaction.com. But this is essentially like the inevitability doctrine, and these businesses now trying to position themselves to capture racial market share very explicitly by purchasing the community influencers of different racial demographics.
Do you want to try the video for one last time? Maybe my new window will play it.
Sure. Here you go. This is actually, if you scroll up in the lobby, what you will see is you'll see it is there's a start thing on it. Hold on a second.
Oh yeah, I see it here. Let's try it.
It's YouTube like .com backslash yeah, there it is. It says play here from 41:56 to 43:49.
No, not playing. So it seems that my wild Adobe Flash Player update didn't do it. I'll probably need to restart. But I think that we can end it for today here, unless you had anything to add, and we could do a part 3 on this. This is absolutely stunning. In terms of what you've demonstrated today, you've shown us that the diversity industry has legal arms and they're using it. And the current economic system in the US is spending billions of dollars to things that are not meant by the free market, that are not to the service of anyone except the beneficiaries of these measures, which probably lowers the productivity in America considerably.
Yep. By the way, EA, what is the full name of EA? Because I just typed in EA racial discrimination. I see one from 2016, but I'm not sure if it's the same EA.
EA Sports, EA Entertainment. The full name is Electronic Arts.
Okay, let's see. Dun dun dun. Oh, Electronic Arts. All right. Hold, please.
Well, they are listed. Oh no, that's another article.
CGE. All right. Well, let me look into this a little bit later. Obviously, Google is easy, but let me look into this and post it later on my Twitter. I'm pretty sure I can find. If not them, who is their parent company? ESPN? Is that? Because they may have just sued the parent company.
Electronic Arts. Let's look at the Wikipedia page.
Here's one of NASCAR being sued for $500 million. Self-styled diversity guru drops $500 million discrimination lawsuit against NASCAR. Let's see if I can. But
no, it does seem that it's the second largest gaming company. They don't seem to be. They have partnerships, but they don't seem to have been eaten by a bigger player.
All right, let me do my own research on this first. But then if I need to concede defeat, I will. But I am seeing something from 2005. Okay, all right. Well, we'll do it.
Now, I'll say that just by Googling it, there's another subject that popped out, and I'm quite shocked. B&H Photo, which is where I buy all of my video filming material. They've been targeted by a lawsuit. I see B&H discriminated against Hispanic workers, Labor Department lawsuit says. And so I'm quite shocked to find my supplier of streaming and video and audio material has been catched by these suits. 4.3 million in 2007.
Yeah, that's nothing. All right, well I guess let's call it here. The last one will be kind of like the last one in the series will be kind of like an applied version of it to tie it all together so that you can see how it looks like with Starbucks specifically.
All right, well, Frame Games, it was a pleasure hearing you again. You are so in depth in your analysis. Oh, we do have some super chats before we leave. Sure. Shell Beach says, we need to reverse the lawfare paradigm. Non-whites need to know this information. Get them out there Get them out there suing, suing, suing. That will get the laws reconsidered. So he's essentially suggesting an accelerationist view and say the more there are suits, the more the system will have cracks. Cattle F says, I love breast milk cereal. That doesn't make sense at all. Globalist Juice, $25, says, always enjoy your show, JF, and guest. Thank you, JF. Well, thanks to you. Brian Jones says, I work at one of the largest tech companies in the world, and I'm routinely told to have less white people in ads. Ironically, company is like 20% Indian. That's what we're going to find ourselves with. These cases never being sued of discrimination against white people or randomly favoring Indians or Asians. It's we're going to end up with all companies being either equal or unequal toward whites. Aussie News Network saying, sending $50. Thank you so much. He says shekels to JF and Frame for another awesome show. And Red Pill Raccoon says millennials equals neo boomers. that kind of I have difficulties wrapping my brain around this metaphor. I will think about it tonight. Frame Game, it was awesome talking to you.
You too, JF. Have a good night. Bye,
Bye
guys.
bye.